this is one more of those really fruitful sessions from the Retailers Association of India. And I'm sure that this is going to be something that each one of you would be able to think upon subsequently to act very practically in your own businesses. As we handle COVID and the repercussions of COVID to all of us in our lives and our businesses, I think it's important to know what are the various legal aspects that we encounter and how do we really deal with them. This session with Jyothi and Suhasa, I'm sure it's going to be really enlightening. Thank you, Suhas and Jyothi, for really taking this time and to be able to get our audience to understand the various repercussions. All of us are very sure that this is going to help us in structuring our businesses. Just for the sake of all the people who are attending this and for the audience who are wanting to get to know the details, I wanted to set up a framework, and that's where my job finishes. I think the framework is very simple. All of us are businessmen, and the businesses requires us to start thinking about how to take the business along with the set of people that we work with, namely our salaried employees, our various business associates, our places where we've taken our shops and hire, so our landlords, etc. So all our business associates form this capability for us to be able to run our business. So while there are various things that gets discussed here, I would always suggest that one has to put on practicality in mind before you take any of the actions. The fact is that we need to be able to survive now. We need to be able to survive 2 months down the line. And more importantly, the businesses that we are in should be a going concern even as of March 2021. So with those simple requirements in mind, I think it will be very easy to understand where Jyothi and Suhas come in from. Both of them have been dear to us at RAI. They've been very good supporters of RAI, and I hope that this is going to be useful for all of you. Thank you very much. And thank you, Suhas and Jyothi.
Thank you. Thank you, Kumar, for setting the context. Yeah, welcome. I would welcome all the participants to this webinar, COVID-19 legal implications, conducted by Retailers Association of India. For the benefit of many, I would like to introduce myself. I'm Jyothi. I'm the General Counsel, Vice President Legal of Aditya Birla Fashion and Retail Limited. And I'm going to be the moderator for this session. And we have with us our esteemed speaker, Mr. Suhas Tuljapurkar. He's a managing partner of Legasis Partners, also founder director of legal tech company Legasis Services. He has about 35 years of experience, rich experience in the area of corporate governance, ethics, and legal strategies, and immense experience in the retail industry. One of the top leading lawyers of India, and we are really happy. We are privileged to have Mr. Suhas with us as the speaker, who will be answering many of your questions and probably giving us some guidelines with respect to our expectations for way forward, as Kumar put it, as to how we should look at life beyond March 2021. Well, friends, all of you know that we are in the midst of this COVID crisis. Nobody ever expected that it would become a global epidemic. We all thought that it just started in Wuhan, and it was a problem only in Wuhan. But very soon it spread to all parts of the world, and we saw ourselves caught into it so very badly. And in March, our government had no choice but to impose lockdown. And the lockdown has now continued. We are in the third phase of lockdown. What happened during this lockdown? Of course, all commercial establishments, basically all businesses which were non-essential, they got shut, while essential goods and services, businesses continued with a lot of restrictions though. For retail businesses, it was a big blow because stores got shut, malls got shut, theaters got shut. One hand, we had our overheads. On the other hand, we had these circulars coming from the government saying that we need to pay full wages to all the employees, including casual labor. And yet, this was not the end. We had also funding issues, lot of liquidity issues. We were not able to, many of the retail businesses were not able to get their working capital financing from the banks. And in all this background, nobody knew the answer as to when, or still knows the answer as to when this lockdown or when this COVID is going to get over. It actually looks like it's going to be the new normal for at least a year or so. In midst of all this, whether it is retailers or whether it is mall owners, suppliers, all the stakeholders in the ecosystem have been seriously impacted because all this had a spiraling effect on all the stakeholders in the ecosystem. And retailers, mall owners, theater owners, hotel associations, we have seen them resorting to various measures, whatever they could, in terms of negotiations of their rents or negotiation of contracts, or when it came to employees, it could be probably paying a part of salary because they were not in a position to pay. So while this is the situation, lives versus livelihood is an issue before us and also the government. And in this situation, we have various new legal issues coming up. Let's look at these legal issues that most of us are facing. It's important to understand them as a concept so that we can apply them appropriately in our businesses. So it is in this conference or it is in this webinar, we are just making a sincere attempt to explain you all the concepts, limitations of them, and uncertainties associated with them. Yes? And definitely whatever views given by the speakers on this webinar are definitely not, should not be taken as a legal advice to be acted upon, because the legal advice would be subject to facts and circumstances of every case. Well, with this background, I will continue my conversation with Suhas. Suhas, you are most welcome. Welcome again to the webinar. Suhas, can you hear me?
Yeah, thank you very much, Jyothi. Thanks a lot. Am I audible?
Yes, you are audible.
Yeah,
Suhas, how do you see the situation? From your own perspectives?
Sure. I think, Jyothi, thanks to you, thanks to Meenakshi, Gautam, Kumar, and RAI. I think, yes, through these dialogues, I think we will try to, try to find out some answers to some of the questions. I don't think we will claim to find answers to every question that we have. And I think the RAI community has thrown almost about 300 plus questions on the legal side, which needs answer. We will try to kind of find those. But just to kind of set the tone, I'm saying, and I will read the caveats out like typical lawyer would do. I'm saying this webinar is for general awareness of legal implications of pandemic 2020, which is COVID 2019. It's not a legal advice or opinion. Based on your facts, before you take any decision, take a formal legal opinion. We're also saying that this is a very dynamic situation. It's not only dynamic, but I think it's uncertain, unpredictable. And what we may identify as risks today, or we may not identify some of the risks today, is going to drastically vary even in a short span of time. Why I'm saying this is because as we speak, yesterday the court kind of Supreme Court gave one order in which somebody went there by way of a PIL and started saying that, this word social distancing is unconstitutional. You can't really, today distance based on caste, creed, religion, age, sex. Therefore, this is unconstitutional. I think the court threw the PIL out of the window and actually levied 10,000 rupees fine on the petitioner. So, I mean, as we speak, there are developments happening, and so it's such a dynamic nature in which today these developments are happening, that it's going to be very difficult for anybody at a point in time to say this is what you should be doing. The second aspect is also it's a major defining movement across the world. In as much as I think even IMF, when it talks about pandemic 2020, it says it's a crisis like never before. The humanity hasn't seen any of these crises or any crisis of this nature. Lastly, I'm saying we're going to take an eagle's view even during our discussion and conversation, and we will kind of then do a deep dive on very particular issues which could be of importance. See, the kind of opinions that we may express here may not necessarily be backed up, or the opinions of our respective organizations. Very clearly, I think if I say something during these discussions, it's not a Legasis view. And I'm sure that's true for you also, Jyothi. I think we're going to iterate that as we move forward. Having said this, I think the impact of COVID is 360 degrees on anything and everything that we do today. Whether it is corporate laws which have been amended, so to speak, that all physical meetings have been dispensed of with. There is AGM you can conduct even via video conferencing. You have a digital board meeting insofar as adoption of accounts are concerned. You have dispensed of with the physical meeting of the independent directors, which was otherwise required at least once in a year for all listed companies. I think there are lots of such kind of amendments that have come in. Along with that, there is a Fresh Start scheme, the Companies Act Fresh Start scheme 2020 that has come up. It's also an interesting scheme to look at. Employment laws have undergone a change, and as we speak, I think yesterday the news from Uttar Pradesh has been that except for 3 critical labor enactment, they have exempted everybody from every other enactment by way of an ordinance. Now, they are impacting. The finance laws, which is like the laws relating to the investment, laws relating to the revenue, fiscal and revenue, all of them, they have undergone change. There is a huge challenge with respect to contractual laws, which is the force majeure, which is the impossibility of performance, frustration of performance of contract, and contractual laws will undergo a change, or we are already seeing a lot of traction in this space, and a lot of hand-holding, advice, opinion, and very careful scrutiny of your contracts is required. Again, investment-related laws have undergone tremendous change today. You look at it, I think, not only from the point of view of working capital flowing from the RBI moratorium-related issues, but there are the debt-denominated instruments being redefined. Insurance laws have undergone a change. These are predominantly from a regulatory perspective. And I think insolvency and bankruptcy law amendments that have been made, where there is a pause currently that for whatever happens in these 3 months, you will not be NPA because of RBI asset reclassification, but you will also not get into bankruptcy for a period of 6 months now, which therefore 3 months of moratorium plus 6 months would probably, we're talking about 9 months pause there on the insolvency and bankruptcy. A lot of people are also predicting that there would be no insolvency focus that was there prior to COVID, and that there is a complete game changer there. So my point, Jyothi, is that every aspect of business law today is affected. It's a 360-degree change, and the complexities are too many. Therefore, if you could just give me a couple of minutes, I'll just try to explain. There are various statutory provisions, there are various legislative provisions that have come up. There are regulatory, administrative, and other authorities have issued what they call, COVID orders. they call COVID directions. There are notifications that have come in. There are regulations, new regulations that have come in, or amended regulations that have come in. There are circulars issued. There are advisories. There are statements, instructions, rulings. All of that, if you look at it as a COVID direction, one, as a student of law, one must understand what is law and what is not law within this. What is it that we need to follow in business, in corporate, or even at individual level? And what is it that it is not a law that is not changing? So what constitutes law is becoming a very, very critical understanding for any student of law today. That's the question, that whether MHA advisory of 20th of March talking about salaries and payments to be made to everybody, is that an advisory or is that a law? Does it have a force of law? It's something which is being now articulated and being adjudicated at the Supreme Court level. Therefore, the situation gets compounded further when we have lots of fake notifications being circulated in the digital media, in the social media, in WhatsApp. And I think, therefore, it's very, very important as a student of law to understand what is law. First, remove the fake from non-fake. And I found out, Govind Ethiraj's boom fact check as a very, very strong proposition that actually deciphers between what is fake and what is genuine. So I think the challenge is such that MHA had to come out with a circular to say that don't circulate fake directions.
Yeah.
Even the advisory was given against the chief secretaries and government officers, saying don't kind of circulate fake directions. You see, therefore, that's the background. I mean, it's a complete game changer. It's like a crisis never before.
Very well articulated, Suhas. In fact, you really gave 360-degree view of this problem. All right, now it's time to go deep into these concepts to understand actually what do they mean. As you rightly said, it's very important for us to understand what the law is right now. Yeah, maybe many of these laws were enacted and or laid down many decades ago, and perhaps may have to be relooked today. But then it's still important for us to look at law as they are and then look at what changes we can expect or how we can apply them to the businesses. So there are many legal issues and challenges today amidst all this chaos. And I must tell you that since we are more focusing on the retail industry in this webinar, and we have 1,700 plus participants who registered for this webinar, and there are 1,000 plus people who are viewing it online on YouTube. I must tell you that 95% of their questions have been around certain specific legal issues, and that's why I think we should focus on them. I think the most famous or the infamous concept, I would say, is the force majeure, Suhas, and has been discussed, debated, confused, whatever you want to say about this today. So there are innumerable articles, interpretations around it, and people trying to kind of lay down laws in their articles, though they are just in articles, right? So there's a lot of confusion, but what has happened is the people who are from non-legal background, or sometimes even the in-house counsels, they find it extremely confusing as to apply these concepts, So let's look at the force majeure, and where do we find it? Is this only section 32? What exactly section 32 of the Contract Act says? So if you can just throw light on it, Suhas, it will be really helpful.
Yeah, sure. I think, when we talk about, force majeure, I think one fundamental thing that we should realize is that it's not codified law in India. Okay, you won't find it in any statute except probably RERA. There is a statutory provision that gives extension to the project deadlines if there is a force majeure event. Besides this, in India, which is like all of us understand is a common law country, force majeure is not a codified law. Whereas in some of the civil jurisdictions, force majeure happens to be a codified law. It finds a place as an enactment or somewhere in the enactment. Okay. What that means for us in India is that therefore it becomes a contractual remedy. And when we talk about contractual remedy, there are two things that one must realize. One is whether in your contract or in your agreement, there is a force majeure provision or not. If there is a force majeure provision, then it's a contractual relief and you have to go under that contract. It will supersede the provisions of the Indian Contract Act. There are 3 or 4 critical provisions of the Indian Contract Act that we have to remember, but remember that they will come into play if you do not have force majeure as a clause in your contract. I'm just putting it in a very simplistic manner. However, these are very complex issues when you try to deal with it.
Sure.
Because force majeure is merely a term. There could be an act of God. There could be an event beyond control of people. So I think as lawyers, we understand this tends to be or could get into a very, very complex situation. But in order to explain broadly, I'm saying, yes, we have to understand whether your agreement, whether your contract has any clause which is like act of God, which is like force majeure, which is like event beyond either party's control. If there is a provision of this nature, then you look at contract and you look at what is the consequence. You have to read your agreement as a whole. You have to look at all the facts and circumstances and then look at what does this mean. If you do not have that provision in your contract, then you have to resort to Indian Contract Act. Indian Contract Act, there are predominantly three sections that one need to focus around. One is section 32, which talks about, what happens if you have a contingent contract. Yes. And in a contingent contract, that contingency didn't arise or doesn't arise, and there is a event which leads it to be a complete frustration of the contract itself. Basically, fundamentally, that's what it is. Section 56, which talks about, understanding impossibility of performance of the obligation, a particular obligation under the contract or the contract itself, which goes to the very root of the contract. It's section 56 there. And then, of course, restoration as to what to do or restoration of giving back the advantage under a contract. Like, for example, there is a buyer-seller relationship where you paid certain advance and COVID situation has happened. So what do you do is what is contemplated under section 65. So I think fundamentally what one has to realize is that, whether there is a force majeure clause in your contract or not, even if though it may not be there, you can take umbrage under whether section 32 or 56 or impossibility of performance, or is there any other material change in contract provision which is there. Material adverse effect or material change of contract are some of the clauses which are there in the contract. So I think broadly what I would like to consider is that, force majeure don't go by whatever is popularly being called, saying that you are excused. If everybody today is hit by the force majeure, such as COVID 2019, pandemic 2020, then all contracts will then get automatically terminated. I don't think that's the law. Therefore, for each person, you'll have to look at what is the contract, what is your arrangement with the counterparty as part of that contract, and then move on to determine what is it that you want to do. Also, very clearly, I think when somebody says act of God, when somebody says epidemic, within the definition of the force majeure, where does this come in? Broadly, if you have a force majeure provision in your contract, it would cover these kind of words such as epidemic, such as act of God, natural calamity, government action, and events, a catch-all phrase, events beyond either party's control. So if these are the words used in your contract, you might say, yes, there is a contractual provision there. But let's understand. The COVID 2019, when it happened or when it broke down, as you rightly said, Jyothi, in Wuhan, and all of us know that. But when it happened, I know CCPIT, the Investment Trade Council of China, issued more than 1,000 or 1,200 certificates saying in Wuhan, this manufacturing unit is now saddled with a force majeure condition because it is unable to operate. So it issued those certificates. There are certain provisions, including in the FIDIC contract, large international contracts, where certificate from a local chamber of commerce is required as a part to say that this has caused me my disruption, or I am unable to perform the contract. So CCPIT went on issuing more than 1,200 such certificates. When I think WHO declared this as a global pandemic, in all probabilities, unless the contract specifies, it dispensed of with this requirement of a proof of saying that I'm affected by COVID, because it recognized everybody across the globe is affected by pandemic. So that's the kind of issues around the principles of force majeure. And I think very importantly, for everybody to understand, I think we have to be very, very careful in terms of saying, what is my duty? What is the burden of proof on me? And what is it that I'm going to claim as a consequence of force majeure? Am I going to say that for 3 months I'm not able to perform my contract? Will that give right to the other side to terminate my contract? Very clearly, that is the first thing that needs to be kind of thought through completely before you actually take any action on force majeure or act of God. So broadly, this is the lay of the land, and this is the kind of broad issue around force majeure.
Oh, that's really insightful, Suhas. In fact, I would like to add to it that we have to look at our contracts very carefully, when we have to apply it, because it all depends on to what extent and in what way we would like to apply force majeure. Whether it is only for the performance for that period or beyond that and things like that. And I'm sure you'll agree with me that even the courts today, we do not know what view will they take in terms of deciding on the rights and liabilities of the parties in view of this. Because most often, at least academically, historically, what we have seen, Suhas, is one party used to be affected by force majeure and the other party would not be. And we would say that, I remember also we amending many of these clauses when, during these instances of like incessant rains, when especially Bangalore had it, many of the people started mending their contracts to say that incessant rains also we should include and things like that. So as and when there were certain situations, we tried to act on these force majeure clauses, but nobody ever thought that a situation would come where all the parties are getting affected and either of the parties could claim the benefit of force majeure against the other, right? So we really do not know how it's going to evolve. All right, but be it as may, I think we should still stick to the contract, and I think the wisdom lies again in trying out a win-win solution between the parties. I hope you agree to that.
Yeah, Jyothi, very interestingly, I think, I must say, although the event of force majeure, which is COVID 2019, applies to everybody, its application in what form and manner it applies to someone is different. In as much as a person who is today in the red zone has a different application of this act of COVID 2019 than somebody who is in the orange zone. Now look at it for the purpose. Now I may be in green zone, but I am unable to ship my goods because the transportation has come to a complete halt.
Yes.
Okay. So for me, somebody might say you are in a green zone, you are not affected. But I am not able to use the supply chain or logistics. I'm not able to export my goods because the ports are closed, because the ships are not available. Transport is not available.
Yes.
I'm not able to use because aviation is not available. Cargoes are not available. So, I mean, qua each of the parties, its application is going to be different. Qua each of the activity, its application is going to be different. I had a case where one of our clients actually sent a notice saying, there's an international contract. This is in a construction side, not on the retail side. But I think the logic and principle is applicable. He sent a notice to his counterparty saying, now I cannot do your work and I am claiming force majeure. There is a provision under the contract. Okay. Bank came the reply from counterparty saying that you have undertaken this contract and large portion of this contract relates to design engineering aspect. Tell us, construction site may be shut, but what prevents you and your engineers from making those designs and provide us those designs during this course where they can stay at home and still work around it? If that is the case, then your performance of part of your obligation can still be done. You can't simply say that I'm completely frustrated and I will not be able to perform any part of my obligation under the contract. So it is going to vary for our person to person. It is also going to vary from location to location. It is going to be a factor where your facts will be more important than merely the law relating to force majeure.
Yeah. So that was really useful, Suhas. In fact, very relevant. In fact, it should vary from person to person, entity to business entity to entity. So you were just explaining to us how Section 32 applies when there is a clause and in absence of which doctrine of frustration can kick in, that is 56. But let's look at a few examples, because there have been a lot of questions from the audience around provisions under the Transfer of Property Act, especially in cases where, the real estate properties are involved. So you have, certain relief under 108, and then you also have Section 56 Contract Act. So what's the interplay between them, or are they mutually exclusive, or how do the parties avail these provisions?
You see, therefore, let's look at it, from the point of view of, do you have a lease deed, which is different from a leave and license agreement? Okay. Leave and license agreement, as all of us understand, is a temporary permission or a license granted to you to use the premises, and therefore the provisions of Section 108 of Transfer of Property Act will not get attracted to leave and license kind of an arrangement.
Correct.
So it will get governed by Contract Act provisions or your contract.
That's right.
In your contract, if there is a force majeure or act of God or any of these kind of provisions, then you will take recourse under those provisions. If not, then you will look at saying, what is the impossibility of performance? Now let's look at that thread. Okay, I'm a tenant, let's say, and then we will look at from a landlord perspective. If I'm a tenant, leave and license agreement, there is no force majeure clause in the agreement, I'm governed under the general law, I will have to prove to my counterparty that I am not able to perform my obligation. What is my obligation as a tenant? To pay rent effectively on time as per the agreement provisions. Now, when I say I am not able to give you rent, that is the lack of performance, or that is the kind of today default of performance obligation. Now, landlord in all these cases, or most of the cases, is saying, I have a deposit with me. The purpose of the security deposit has been to secure my rent. I will appropriate your 2 months, 3 months against this security deposit. We'll look at opening of lockdown provision, and we will see what to do with replenishment of this security deposit. So from a landlord perspective, or let's say licensor perspective here, I think he is safe. From a tenant perspective, a licensee perspective, okay, you're not going out of pocket today. Your problem is your liquidity is an issue. Now, around this, the various solutions and other options are arising. Therefore, the discussion as to whether you should go under force majeure and kind of contest the matter legally or get into adjudicatory forum will be a question which will be of a theoretical in nature, because you will have to look at practically from business perspective, what is it that you want to achieve? You want to achieve cash conservation today and you want to continue to retain the premises. You might go back to and tell the landlord saying, appropriate it against my security deposit. I will see what to do after the lockdown opens up, or after I am able to start performing my obligations, such as conducting business from the premises. See, that's more practical way of looking at it. If there is a force majeure provision under your leave and license agreement, okay, now it's nobody's fault that these premises are not available for business. And therefore, you will have to look at those clauses and work solutions around those clauses in the contract. From a landlord perspective, if I were to wear that hat and look at it, you see, what tends to happen is landlord or a licensor, somewhere or the other, he has tied up his property in a loan, so to speak. And that if he is enjoying a moratorium today, I think its fairness and reasonableness would be called upon to say that if you are not paying your installments and EMI back to your borrower, or sorry, back to the lender, back to your banks, then why should you insist on recovering the rent or the license compensation? Okay, that's the kind of arguments that will be made forward. And that's the manner in which the things will be looked at from a practical point of view. If you want to look at purely from a legal point of view, look at it from a tenant perspective. If there is a long lease, long-term lease there, you're not able to pay the lease rentals, you want to terminate the premises, you should be ready to terminate the premises, because you want to then conserve your cash. You want to make sure that no other claim is against you beyond the security deposit that you have paid. You see, my reading also is that currently there is a law and a Supreme Court judgment which is kind of doing the rounds, which is the law laid down on the leased properties. Okay, it's an interesting case where I think it was a lease arrangement done between a lessor and the lessee for agricultural property, both of them residing in India, for a property that went into partition. And the licensee kind of said, or the lessee told the lessor, saying, please give me my money back. This was agriculture property. So there was this rabi crop that came up. And he said, sorry, I lost the money, but I have paid you advance rent for this agriculture property. Give me my advance rent back. Because now I don't have the property. It's gone there in the partition. And it's a force majeure event. Okay, the Supreme Court actually said it's not a force majeure event. However, applicability of that judgment or the earlier judgment to current situation and scenario will have to be relooked at by the courts. I'm sure, I think there is something which is a far better workable solution that would emerge.
Yeah, you're referring to Satyabrata Ghosh's judgment. And way back in 1953. And we are looking at many decades and trying to apply that. Yes, I'm sure the court will have a fresh perspective on this. But while you just spoke of moratorium, Suhas, I would like to take you to the recent developments on the moratorium that happened. The Supreme Court requiring the banks not to charge interest. Can we just quickly go to that because that's so relevant on the moratorium issue?
Yeah, sure. One second. Yeah, so thanks, Jyothi. I think, is my screen visible?
Yes, it is.
Okay, thank you. So thanks, Jyothi. I think I'll just explain in brief the RBI stuff here, which is, this started off as a monetary policy measures in the Monetary Policy Committee, which was on March 27th by RBI. They said that we have to combat the liquidity issue in Indian context. We want to make sure that working capital financing is eased out. Now look at it this way. If nobody paid any installment, nobody kind of paid any either debt repayment or principal payment didn't happen for a period of 3 months, any account would become NPA. So they said we will first look at asset reclassification. So asset reclassification happened. And then they said, what is the best thing that we can do as a regulator through a policy mechanism? And this was a policy mechanism where they said that the board of directors of each bank should come out with a policy which is in the nature of giving moratorium to their borrowers. So what happens is, during the period of this COVID, and they contemplated it to be 3 months, that even if you are unable to pay your debts, you are not unable to pay your installments, this will not be considered as a default. That's what moratorium is about. It's not about waiver of interest. It's not about anything else, but say that for this 3 months period, if you are unable to pay debt, you don't pay your EMI, will not be default. Now, look at it. This applied to everything. It applied to your credit card payments. It applied to housing loans that you have taken, commercial premises loan that you have taken, corporate loans such as your long-term debt, which is secured, your unsecured debt, your CC, your BD, your OD limits. This applied to every loan that was there in the field, individually and at the corporate level. You see, all large corporates, 300 plus large corporates, actually availed moratorium to say that we're not going to pay installments. Now, if this installment is not paid to the bank's balance sheet will come down. Bank's books will show that the banking sector will collapse very soon. So what happened is, they said this will be moratorium so that the bank can do its classification of its asset, and also clean up their books. Their books will need not be provided for this default, for this three months kind of non-payment of principal or interest. That's how the first portion of RBI happened. RBI guidelines happened. Now, this got applicable to all NBFCs, including the real estate projects were made applicable on April 17. There were lots of issues. The clarifications came in as to what is the moratorium. And when the question obviously came as to, this is a policy measure, you're telling the banks and boards of the bank to actually come out with this moratorium. Is it legally enforceable? As an individual, can I actually tell my bank saying, this is what RBI said, now therefore forget whether you have policy or not. I want to avail this moratorium. I want to make sure that this 3 months debt is not repaid. So the matter went eventually up to Supreme Court. Supreme Court said, we're not getting into individual cases here, but we are saying that this circular needs to be implemented by RBI. Now, what RBI does and how it implements is left to RBI, but it has to be implemented in a letter and spirit of that circular. So it became virtually a circular or a policy measure which is implemented like a law because of the Supreme Court order today. So it became an enforceable directions. Yesterday, I think there was another petition in the same matter that came up before the Supreme Court, where the question was, somebody said, for these 3 months, why should there be moratorium and why should there be interest payable?
Yes.
In future, you are either extending my tenure of the loan or you're recovering this from me. And
Yeah.
I'm losing my business today. I'm losing my salaries today. I do not have ability in future to pay for these 3 months. Therefore, please make sure that nobody charges interest for these 3 months. Supreme Court has called upon RBI, or I think the Solicitor General actually said, I will seek instructions from RBI, and then we will kind of file a reply, and we will see how the matter moves in which kind of direction today. But I think the role of RBI in terms of capital financing, in terms of easing out the working capital requirement, has been upheld, and everybody has talked greatly about what RBI has done under the circumstances.
Yes. Well, that brings me to this another point, of course, MHA order, which again has been widely discussed, and then people have expressed a lot of concerns about this MHA order requiring all the employers to pay full wages to all their online, offline employees. So basically on-roll, off-roll employees, and and uh, and in a situation where retailers or many employers claim that there is no business, there is no cash flow, there is absolutely no revenue, and how do we pay? So what are views? I know there have been a few petitions, before the Supreme Court today, challenging the validity of this, the MHA order. And we also know that Supreme Court has given some time to the government to file their explanation. But Suhas, the question before us is, of course, none of us are in a position to predict what Supreme Court is going to say. But I would want kind of to know, what should the retailers do, or what should the employers do during this situation when they are unable to comply with the order because they just do not have the wherewithal to do that. So, what would be the right way to do it, or should they wait for the court decision, or should they take some decision, on their own? What's the way out for them?
Hey, Jyothi, thanks. I think this is a very, the most talked of aspect of COVID-19 qua the employers or the employer-employee relationship today. It's not very easy to answer that. And let's first focus only around, let's say, retail industry. I will not get into, manufacturing units, factories, and other kind of establishments. Let's stay focused around the retail industry part of it. You see, one, I think we need to look at those employees who are covered by a contractual individual arrangement. So in a sense, they're not largely the workmen category. For them, I think each of the employer has to sit with the employee or set of employees and actually come out with a consensual arrangement by way of which what you are going to do has to be implemented. In a sense, if you want to terminate that employment, then you will have to look at 3 months notice to be given, or whatever is the notice period in your contract of employment. Follow the procedure so that it's a rightful termination of the employment. This is only insofar as the employees who are governed by way of a contractual relationship. You see, if there are workmen category of employees, I think you will have to look at what applies to them. But even before that, I would say, since that matter is now sub judice before the Supreme Court, and there are a host of other variations that have gone in there, in as much as one is about whether MHA circular that talks about payment to the workmen during the period of lockdown is to be strictly construed only during the period of lockdown. If there is a release of lockdown in green and orange zone, then that circular no longer applies, and is the employer then free to deal with its employees the way he was otherwise free to deal with? That's a question that's being raised there. Secondly, these salaries, wages mean what? That's also a question that's being asked. Thirdly, and very importantly, the kind of questions that are raised there is to say that if government is telling the business or the employer to say that notwithstanding anything else, you got to continue to retain these workmen with you and continue to pay them, does that mean that even if I don't have money, how am I going to pay? Is the government therefore going to give me subsidy? Is the government therefore going to give me 70% of wages, 75% of wages, 50% of wages? What is it? You see, therefore, that's again a question that is pending adjudication before the Supreme Court. There are some judgments that have come in an ad hoc manner from Bombay High Court and Kerala High Court. Kerala High Court says you got to pay 50%, or you cannot pay 50%. There is a very interesting thing happened in Kerala. In Kerala, the state government came out with a circular saying we are going to deduct some 10% odd wages of all the government employees. I think that circular has been stayed by the Kerala government.
Yes.
Kerala government also said on a 50-50 formula, you got to make sure 50% gets paid. Now, all of these matters will get decided by the Supreme Court. The MHA related issue would be decided in the Supreme Court. In the meanwhile, you see, my view, and which is a practical advice that I would like everybody to consider, is that pay whatever you are able to pay in an ad hoc manner as ad hoc payment made for this period. Let the Supreme Court judgment come out. Let there be some clarity as we move forward. and then decide in terms of what is the treatment that you are going to give with respect to these all these issues. Uh, Mindful of the fact that government itself has frozen the dearness allowance from January, and they're
Yes.
going to freeze it for next 2 quarters.
Yes.
So they realize that the dearness allowance is something which is frozen in time. Although the obligation to pay DA is there, but DA is frozen. So there is no enhancement, there is no increment, there is no addition to the salaries that were there, at least in the government and government employees and the pensioners, central government employees and the pensioners. So the dearness allowance has been frozen there. Bombay High Court has come back and I think announced in one of the interim orders that please, there is no requirement now of payment of conveyance allowance and
Yes.
things like those allowances.
That's right.
Food allowance, conveyance allowance, blah, blah, blah.
Because
But
there's no work happening. There's no work happening. Yeah.
Because there's no work. So I think my advice would be wait for Supreme Court to kind of give this clarity. It's not very far because I think the matters are posted on the 15th, if I'm not mistaken. Hopefully the matters would be heard. Even if nothing comes on the 15th, very soon some relief would come. In the meanwhile, I also believe that there are some of our clients who have received letters from the Labor Commissioner to say that please pay to your workmen and don't retrench them during this period. I think it would be prudent to write back to them to say that this matter is sub judice before the Supreme Court, and we will take the call after the Supreme Court clarity comes in.
But we also read that in the newspaper that Labour Commissioner Pune, I think, has already issued a notice to Wipro for, again, violation of the MHA order. Well, we'll just have to wait and see what happens, Suhas. I think now it's time to, let's, principally or theoretically, let's move out of this lockdown period and look at what lies ahead, post-lockdown. So if you look at it, yes, you may say that MHA order may not be applicable then, and the employers will be left to restructure their businesses or their workforces in a manner that is most suitable to them or most appropriate in the circumstances. So many questions have been asked around what options do we have if we were to restructure our workforce. So before that, I would like to kind of quickly get a clarification from you, because many people think, especially in the retail, that think, oh, ID Act does not apply because we all come under shops and commercial establishment. So maybe a quick clarification on that before you actually tell us what are the options available under the ID Act.
Oh yeah, Jyothi, I think a very interesting aspect is that, and the perception that ID Act does not apply to shops and establishment. It's something where I think there are Supreme Court judgments which have decided this point to say that insofar as matters such as layoff, retrenchment, termination of employees are concerned, the provisions of the ID Act will apply. So its applicability is not because you're an industry or a factory. Its applicability is not because your terms of employment are governed under ID Act. Its applicability is because of the issues such as layoff, retrenchment, stoppage of work, etc., etc. On that realm, I think there is a clarity because of the Supreme Court judgments which hold the fort. And it's more than one judgment. There is a Bata Shoe Company judgment, and there are various judgments that really say that the Shops and Establishment Act related provisions or the model standing orders and its consequences, or the industrial standing orders and its consequences, will not be applicable insofar as retrenchment, layoff, and such provisions are concerned. They will have to be dealt with under the Industrial Disputes Act.
Yeah, but Suhas, having said that, I must tell you that if you look at a retail store, generally, come to the, the ID Act. So when you look at the ID Act, Chapter 5A or Chapter 5B do not apply to these retail establishments. Reason one is, Chapter 5A applies to factories, mines, plantation with more than 50 people, and Chapter 5B applies to employees more than 100. And if we are looking at retail establishments, then we have to rely on Industrial Standing Orders Act, which is again a central act, and which all of us again know that each state has passed an amendment with respect to applicability. If you look at Karnataka, it is 50, and then maybe another state has probably 30, and then 20, and things like that. And of course, the law also very clearly says that where you don't have certified industrial standing orders for your establishment, then you will have to fall back on model standing orders. So model standing orders definitely apply, contain the provisions relating to stoppage of work. So I would say that layoff is definitely provided there, layoff provisions, though we may not get it in the ID Act. But Suhas just explained to us, because layoff also, if you look at the way it is worded in the model standing orders, you take any state except the 4 states which are like West Bengal, Kerala, Rajasthan, and Punjab, which have slightly different provisions. Just explain to us how, the wording of these layoffs in these model standing orders. Don't they give us a sense of temporary stoppage of work, or what's your view on that? Like, what do they say? And do I think them that, I have to just pay 50% because even under ID Act, I would have paid 50%. What's your view on that?
You see, Jyothi, I think it's a very interesting aspect, right? As to what applies to a particular establishment, and I'm in complete agreement with you that there is a stoppage of work there in the standing orders. What is contemplated under that stoppage of work is a temporary stoppage of work. I don't think the letter of law contemplates a stoppage of work for COVID-19 kind of a situation. I don't think that's contemplated. There is an epidemic mentioned there, but at the same time, it also talks about layoff. It also talks about subsequently retrenchments there. In almost all standing orders, that's the manner in which I think this space is dealt.
That's right.
So I completely agree with you. There's not too much of guidance from the manner in which, whether it is industrial standing orders, whether it is central, whether it is respective states, model standing orders. I mean, they don't give you that clarity, and they probably do not contemplate this kind of a situation. Is my reading of the situation.
So you have to fall back, then you will have to fall back on the contract of employment. Then, as has already been decided by the Supreme Court, right? Which is the Fire Tube Tires Company, something like that. So I think that's about in 70s, there was a Supreme Court judgment.
Yeah,
so
78.
Yeah.
I think it's Krishna Iyer was on the bench, although he didn't write the judgment. It was Firestone judgment that talked about various states having various different standing orders being applicable. Some of them they give you right to lay off, some of them they don't, some of them give you right to retrench. What happens, how much amount of salary has to be paid, how much amount of compensation is to be paid during notice period, and all that has been dealt with by the Firestone judgment. But I think today's situation is not that. It was probably at the Firestone level that these kinds of issues came up, and they took umbrage under the standing orders, the model standing orders that were applicable to their respective states. However, my view is that when you talk about today something like whether you want to give a layoff to the people because of this, and your question was very interesting, saying post COVID what do we do? I mean, do we have ability to continue the business in the same manner? Do you have to reduce your business? Your top line is not going to be the same. So how do you kind of truncate your employees, and do you really go after layoff retrenchments? What do you do? My view is that in these kind of situations today, at least insofar as current situation looks like, it's a safe bet to look at layoff as an option. You still have right of retrenchment in future. However, you follow the provisions under Industrial Disputes Act and don't go by the model standing orders.
But but then when it comes to applicability, that is a question, right, Suhas? Because it ID Act may not apply straight uh, to the
Not to the you see, not to the cause, in a sense, not to the cause of layoff, but procedurally, what
Okay.
do? Is the guidance there? But again, I mean, don't go by saying that layoff is a normal standard law that will apply now. Don't. Again, I'm putting that caveat here. I am saying, first, let's wait for the Supreme Court clarity to come as to what do you do during COVID period. I'm sure the clarity will also come as to what will happen to the consequences of the COVID period on the employer-employee relationship. And I think I see a lot of change happening on the employer-employee relationship per se.
Yeah, that's right. Because with the new norms coming in, like social distancing, and if you look at all the MHA guidelines today, stores can be opened with 50% of the employees or less than that, and stuff like that. So we may not be, like employ all the people there, though we would want to, right? So there are questions again from many people saying that can we change the working conditions of the employees? Because yes, earlier I would have perhaps engaged an employee for 9 hours a day, and perhaps I had 2 shifts in a day, right? Because the stores would be open from 10 to 10 in the evening, whatever. Again, depending on the local laws. But now we may not really need 2 shifts. We may just need 1 shift. And even if I have to distribute the workforce using just 1 shift, then I may have to change the working service conditions. So if you look at service conditions, okay, there is a provision, section 9 under the ID Act, which says if you want to change any service conditions as provided under Schedule 4, you will have to take 21 days notice, issue 21 days notice, and then also intimate the authority. So is that also a good option in your view, because that's available in the ID Act?
Yes, I completely agree with you, Jyothi. You see, having your own terms and conditions of service, you follow the ID Act route, or you have your own kind of a certified standing orders. Either of the route is where you get into consensual arrangement with your employees, whether it is reduced number of people per shift, whether it is reduced number of hours of employment, whether you want to consider this as part-time, full-time. I think it's better to get into a complete consent and get into a consensual arrangement and follow the procedure. If you go under ID Act and adopt it under Section 9, or go under model standing orders, go under Section 7 for change and get into certified standing orders. But my request is, everybody should be very careful and don't fall flat on the procedural aspects. Okay, while your intent may be very good, that you want to make sure that the number of employees that you have today and the working hours and their terms and conditions of wages commensurate with my business size and the business compulsions today, I think my request would be to kind of consider following procedures correctly.
Correct.
Because that's where we've realized most of the time people falter.
That's true. That's true. Because it might be a simple intimation to authority under 9A, but then, yeah, I think the procedurally that has to be followed. Though it might look like, oh, it is so obvious, I've taken already consent of the employees.
Absolutely. Yeah. A seasoned general counsel is speaking, Jyothi. I can sense that.
Yeah. So I would like to kind of draw your attention to this this provision of Maharashtra Shops and Commercial Establishment, while I'm talking about changed service conditions. There is a provision in Maharashtra Shops and Commercial Establishment and of course rules wherein you can engage people for part-time, like basically not exceeding 5 hours and things like that. So, would you advise this being adopted in other states also? But of course, subject to Section 9A route, meaning all.
Subject Section 9A. I'm saying, yes, just follow the principles.
Because Karnataka doesn't have an equivalent law, but definitely that can be one of the proposals that can come under Section 90. And of course, it has to be subject to consent. And then there's a lot being talked about retrenchment and all of that, of course. But I'm sure you'll agree if you go under retrenchment, then there are payouts like a month's salary, and then after that, 15 days of compensation that to gross wages for every year of completed services. So retrenchment also is yet another option that we have seen under the ID Act that's applicable. With all this, do you think all these provisions that we are talking about for application to workmen, should we also have a similar philosophy when we apply to casual or not casual contract laborers, or do we just deal it under a contract?
No, my view there is first look at, is it contract for service or contract of service?
Yes.
Is the contractor registered under Contract Abolition Regulation Act?
Yes.
If the contractor is registered there, you are principal employer, but at the same time, whether to continue that employer-employee relationship at the first level is between your contractor and his employees. He has got right to terminate, etc., etc. So you actually mandate him to say that, okay, I was taking 20 people from you last month, but sorry, now I can't take 20 people. You want to modify that, and please modify your license, your registration conditions, and I just want only 10 people. I do not want 20 people.
So this will be achieved under a contract itself.
Correct. Achieved in the contract itself.
Okay. And coming to the non-workman category, we generally they are called managerial category and all. So they should necessarily come under contract of employment, right? So we don't have to go through ID and all other things for them. It's contract of employment.
Absolutely.
So terms can be changed by mutual consent with such non-workman category.
Absolutely. I think a couple of trends I must mention is that actually the senior managerial category today, senior category like the KMPs or C-level executives, are actually saying that we don't mind looking at sacrificing our salaries, our increments, our variable pay. We will look at what is the universal basic income that I need to survive myself. I will only currently draw upon my universal basic income or my basic income. And rest we will see if the business, as Kumar laid out, at the beginning of this webinar, we are looking at how do you survive during this period and how do you become a winner in 2021 or 2022. So I think at the C level, our experience is that people are saying voluntarily coming forward to say that I will only draw basic wages, basic income, which is far, far less than the entitlement. That's happening at a senior and senior managerial levels. With the middle management, I think most of the time what has happened is that the performance incentives for 2020 have gone out of the window, because last 2 months or 3 months prior to that, because of recession, and during the last 2 months of the last financial year, the targets have not been achieved. The performances have not happened in most of the cases. Therefore, the variable pay has gone out of the window.
That's true.
Also, variable pay for this financial year is currently also out of the window. Having said that, I must caution one thing. If you remember, there was this Provident Fund judgment that came in early part of 2018, if I'm not mistaken, to say that if your variable pay principle is applicable universally in your company or in your team or in your department, then you have to consider that for deduction of Provident Fund. I mean, we got to be careful in looking at that aspect before we take this stand of variable pay going out of the window, your entitlement not being there, or reducing the portion of those salaries. I think that's one kind of a caution that I would say need to look at.
That's really useful, Suhas. So there have been like very recently a lot of circulars with regard to relaxation of certain timelines or procedures in terms of filing the annual returns under various laws and all. Can you share some of them, because that seems to have helped some industries?
You see, these are, in my view, these are compliance requirements, and I think yes, there are the timelines for complying have been extended in most of the cases. In some cases, there is an automatic extension because it's impossible for you to comply with those conditions. Uh, the courts have been very lenient in as much as, let's say, about 3 days ago, the Supreme Court of India came out to say that all limitations and the kind of limitation under arbitration, as well as limitation with respect to Section 138, etc., would get postponed automatically. So I would not worry too much with respect to timelines of compliance at this point in time. But once you reopen, the compliance is going to be new norm. And that compliance will also talk about compliances qua your standard operating procedures, not only the kind of laws, and how you're going to deal with those SOPs is going to be very, very critical. We are making an attempt to put together a bundle of package to say that, back to school approach, like back to work. What does it mean now? You see, so I think yes, there are these extensions given across various statutory provisions on the compliance to to look at the ease of compliances, let's say.
And there have been some questions about these apprentices being engaged in the retail establishments, and what do we do if we have to novate their contracts or terminate their contracts? So the question is, can we do, and do we need approval of the authority?
Absolutely. I think the Apprentice Act is quite clear. If you were to novate the contract with your apprentices, I think without the authorities' approval, you can't novate it. Don't make an attempt to do it on your own, even though you may have a consent of the apprentice. Still, you will need approval of the authority before you actually novate or change any of the terms and conditions of the apprentice, whether it is wages, whether it is employment, anything of that kind.
But I'm sure definitely, the authorities will take it, like in a most practical way, I guess, when they have to give the permission.
I'm sure about that. Yeah, I'm sure about that. Again, I'm saying be careful about the procedure. This is procedural aspect. You've got to take approval of the authority.
That's true.
That's essential.
So coming to the changes that we are seeing now, Suhas, you are, like with a lot of restrictions and still fear. They say, there's a lot of fear mongering happening. A lot of fear in the minds of people. Even if the lockdown is lifted, you do not want to go and do your shopping. You would want to perhaps do only a e-com sales, e-com shopping, right? As a result, what's happening is e-commerce is really getting, I think the scale is just scaling up right now, the business. But in that context, as retailers, I see a concern in terms of online counterfeiting issue, right? So that's something that really concerns us, because it's easier rather, to go and conduct a raid in a certain place when you know that there is a demarcated shop or a factory or a warehouse where the fake goods are being sold, and I seek the police protection, I take action, could be seizure and, the shutting down and all of that. But then when it comes to online, it's like mushrooms. It's just mushrooming growth. Like you just stop it today and then it starts again tomorrow. So what are your views on that, as to how retailers can look at now the online monitoring of this?
Yeah, I think, see, Jyothi, one other part which kind of worries me is that, post the COVID directions, post the lockdown getting released to an extent, I think there is going to be a flurry of activity. That flurry of activity is going to result into counterfeits, or the movement of counterfeit goods, major movement is likely to happen. That's definitely a problem that needs to be focused and solved around. See, long time back when I started my career, I was actually doing for one of the multinationals only asli nakli wala dhanda as a law officer or law officer there. So actually, counterfeit products will come to the forefront. I'm just drawing one parallel. What laws apply to it is actually predominantly the trademark and the copyright and the intellectual property laws will apply. The Copyright Act is many a times is where we have actually gone and booked the cases.
Yes.
I just draw a parallel to my experience with the state of Maharashtra's digital crime unit, where when it came to anti-piracy campaign in the on the in the internet space, in the digital space, pirated movies and pirated music, together with Motion Picture Association of America (MPA) as a trade associate and some of the industry leaders, we created an infringing website list (IWL) together with Digital Crime Unit of State of Maharashtra, and actually started publishing, and not only publishing saying that these are the blacklisted websites, but we started publishing the individuals who kind of uploaded the content there. Then through the technology we identified who these people are, and we created a platform by way of which automated notices went to them. And these notices were like the same thing that we did in the physical world, to actually go and conduct a seizure there or carry out a raid. In the similar manner, we kind of took action. Now, a couple of things that we did was to actually take a very aggressive position, and we automated the entire workflow by way of which the notices could go there to those people and the advertisers on their website. You see, what became very effective is we went to those advertisers to say that please don't advertise yourself on this space because they are carrying or they are infringing website or they are under the IWL list. So actually the infringing websites revenue model suffered. Plus they had this threat of prosecution. So I think on a given case, we can work at a state by state level to facilitate these kind of platforms where action can be taken in a seamless manner to address the counterfeit, because we all know whether it is pirated content or counterfeit products, I think everything goes down to through the dark web or otherwise actually goes down to fund terrorist and those kind of activities.
Yeah, I think that's the main concern. That's the main concern, because it's just not about, when it comes to apparel, somebody said, hey, how is that going to really affect me if I'm going to wear a counterfeit product? It's not going to really matter to me. But actually what happens is all the funds, they do go for all illegal funding, right? So that's a big concern for the society. All right. So I think we should we should look at more ways of having these online infringements controlled through online processes itself, because I am not really sure how successful or how practical it would be for us to do those raids and seizures as we used to do just about 2 months back. Just about 2 months back. Yeah?
I agree with you completely. Yeah.
All right. So now, Suhas, we are almost coming to the fag end of the webinar. And in fact, what I have done is all the 400 questions, you would see that I have put them in these buckets so that every question gets answered. So we haven't left any question that is not answered, because all these questions covered one or these, whichever we have been discussing so far. But yes, there are a few questions on this as to, there are many people would want to know what would be the new normal. Because even today you are seeing the government using the same words. It's saying, hey, this is going to be the new normal. COVID is going to be the new normal, and you better wear masks, you better use sanitizers, etc., etc. So for retailers, especially, or the people in this ecosystem, what do you think should be the new normal ways of functioning? What they should look like, their SOPs, or their business models and things like that?
Yeah, Jyothi, it's a very important thing in a sense. You see, SOPs will become very, very critical to follow. And therefore, from the point of view of standard operating procedures, that right from WHO down to the local self-government today is focusing on creating these SOPs. Now, its implementation is by and large in our hands or in businesses' hands when the businesses start opening up. And I think, notwithstanding the various constraints that we may have, I think following these SOPs is going to be the new normal. It's going to be new normal from various aspects, whether it is terms and conditions of employment of your employees, whether it is engagement with your customers, whether it is your store layout, for example. Probably there is a change required there in the store layouts. Probably there is a change required in the manner in which the tiller addresses the payment related issues. So I think all across SOPs will become the new norm. Implementing SOPs, and people are going to come to your store if you're following these SOPs very well. In a sense, earlier everybody was gauged around the attractiveness of the store. One of the elements for attracting customer is going to be your adherence to SOPs. That's going to be the new norm. In that sense and scenario, I think it's going to be very, very important to understand if you falter on SOP, what is likely to happen. Very clearly, when I think in the orange and in the green zone, when permissions were given for manufacturing units to start manufacture, one of the conditions was saying, if you do not follow SOPs, we will come and shut down your business once again. You will be forced to get into lockdown, and this time it will be 6 months. So this is a consequentialist approach towards following SOPs. Notwithstanding that, the MHA had to actually write a letter, a DO letter to the chief secretaries to say that, okay, we have not given any directions to you, or please do not arrest CEOs of those entities who, after having been allowed to be released from lockdown, are not following SOPs. So to the extent of arrest of CEOs of that unit is the talk that's going around. Although, thankfully enough, the MHA came out to say that don't arrest these guys, don't arrest the CEOs. But what is going to hurt is the business continuity. If you are forced into lockdown subsequently for 6 months, then your business will come to a halt. And I think that will force you again into looking at SOPs as the new norms. Now, around the SOPs, there's going to be new set of compliances that are coming up. As I said at the beginning, when we talked about caveats, we see some new legislation coming up, which will deal with COVID situation, which will deal probably with the consequences of COVID in a comprehensive manner.
Like I think Singapore has come out with a very comprehensive code to address all the COVID-related issues in various legislations. I think maybe that's a need of the hour for us too, because you can't just bring in a change in isolation. It's just going to be impacting everyone in the society, in the ecosystem rather, right?
Yes. You see, Jyothi, lastly, I would just want to focus on what the courts are doing.
No, before that, I think I would quickly want to hear about the very, mostly debated Arogya Setu privacy issues and safety issues. Maybe quickly on that before you touch upon the judicial trends, basically.
Sorry, I missed that.
I said before you go to judicial trends, maybe quickly you can just touch upon, Arogya Setu app being mandated to be implemented by all the employers, and then safety issues being discussed across the country. So maybe a short discussion on that before we go to the judicial trends and then come to end of the webinar.
Yeah, I think MHA has said this, and I think government is trying to say that everybody needs to download Arogya Setu as the app. Now, the Arogya Setu is a contact tracing app that's been developed. Now there are lots of issues with it. One of the preliminary issues is about the data privacy and data secrecy. The second issue is about whether I can completely rely on Arogya Setu today or not. Is another factor which people are kind of talking and raising questions around it. Although its efficacy is not what I would comment upon, but I would say that the first thing that needs to be addressed is whether it is mandatory for those people who are going to, those of your employees who are going to come to work, or it's a mandatory also for those people who are going to work from home. You see, that's another area which is ambiguous today, the manner in which it has come out. While the heading of when they say that every employee should have Arogya Setu, I think the heading of that chapter is uh, permission to work, but every employee is mentioned, not only those who are coming for work. So I think there is a question saying if you're working from home, whether you need to kind of download Arogya Setu today. Secondly, I think the data privacy perspective is very critical there. I mean, there is no provisions which are typical of a data privacy provision that we understand and talk about, which is to say that if this is being used only for COVID-19 purposes, there has to be a sunset clause here. There
Absolutely.
has to be a period by way of which this data will not be used. Okay. If government, if the Supreme Court has recognized data privacy as the fundamental right, then I should have ability to say, I'm not going to upload my data on this. I'm not going to upload my private data on this app. You cannot force me to do that, because then you have to provide limits to the access. You have to provide data deletion deadlines there, and you know you have to give me oversight of controlling my own private data.
Absolutely.
I think these issues are definitely of critical importance. Although the efficacy with which you will come to conclusion about how many COVID cases are there within vicinity of your 1 kilometer will all depend on everybody, logging on to that app and using Bluetooth or your own devices and switching them on. So the efficacy is a question, its reach is a question, and its data privacy related issues are a questionable issues today.
Yeah, understand. And uh, it is such a irony that while we were all just about some time back, we were all discussing, seriously discussing implementation of data privacy laws, and the government was trying to push this bill, and then here comes this app, which seems to be heavily criticized by the privacy experts. But anyway, I think the government probably will have to clarify. I think they already, I recently read, they will say that, we will orange zones, how many months they would like to retain the data, and the green zone, how many months, and things like that. So maybe if the government can give that assurance, perhaps the app will become indeed a really useful tool to, address the situation. Well, we come to the last, I would say, the last leg of this webinar, and then let's quickly touch upon the judicial trends as to what's happening, and then we can close our discussions, Suhas.
Yeah, sure. I think I'm going to just put one slide, uh, which is actually what's happened at the court level, and in a sense, at one place and one level, I think what we as kind of lawyers who like to work around together with technologies we're trying to do is to say that we move towards adopting the newer technologies and becoming more electronic. I think COVID accelerated that entire process, and suddenly, I think overnight we have video conferencing as the norm while conducting the court hearing. The courts have become virtual places. Filing has become e-filing. Uh, Although currently the courts are saying uh, we are going to hear only urgent matters, which are critical life and death matters. There have been instances where people have gone there and said, my matter is urgent. Actually, courts have levied cost on those kind of litigants to say that don't waste our time. Okay, urgent means really life and death kind of a situation. In almost all, by the judicial orders, I think the stay orders and the injunctions have been continued. If you recollect, I think last year there was a judgment from the Supreme Court saying that all the stays granted where there is no date mentioned would automatically expire after a particular period in time. But I think now, in this COVID 2019 situation, I think all orders and injunctions will automatically get extended. But if you have a doubt, it's better to kind of today go back to the court, make that urgent application and get that clarification order from the court, which could be a judicial order that will bind your case. You see, we've created a resource center with all the COVID directions and including the judgments that are being passed by the court at the interim level or ad interim judgments which have implications all across, or some of the cases where there are final judgments delivered. So on the COVID as a subject, there are about 70 plus judgments or orders that are relevant and that are interesting for everybody to look at. One of the ones was, the earlier ones was a share pledge invocation that was stayed by the Bombay High Court, where one of the parties, went to the court to say that there is a lender and it's an NBFC actually tried to invoke the share pledge of the promoter's shares or the owner company's shares in wake of the fact that the share valuations went down. The value of the shares actually drastically went down. And I think this was seen to be a mala fide action, or at least not a very proper one. The stay was granted. The matter was to come up on the 4th. It's been further adjourned. At the interim level, the matter went up to the Supreme Court. Supreme Court refused to interfere in the matter. Then there are cases where the bank guarantees have been stayed, or invocation of the bank guarantees have been stayed by Delhi High Court, by Mumbai High Court. In one case in Mumbai High Court, that has been rejected by the Bombay High Court, because they thought under the garb of this COVID situation, the parties were trying to kind of push their own agenda and brush aside their defaults that happened prior to the COVID situation. Then on May 6th, I think the issues came up for extending the limitation for Section 138 complaints, as also limitation under Arbitration Act for filing or for filing any suit or taking any legal recourse. I think the Supreme Court has extended both the limitations under check bouncing cases as well as under the Arbitration Act. But what was kind of tried to be done during the course of the hearing is, I think, an articulated response was given to the Supreme Court by amicus curiae to say that, why don't you carte blanche extend all the limitation for all statutory purposes? I think the courts have declined to do that. Of course, I talked about the 10,000 cost being levied on a flimsy PIL that came up before the court to say that, sorry, stop using the term social distancing because it is unconstitutional. It kind of violates the fundamental right to life as well as liberty, etc. I think the courts have thrown that PIL out. There are various other judgments which are coming in, which are in the nature of advisories, or which are in the nature of, for example, one of the first ones that Supreme Court came out with was whether and how much amount should be charged for COVID testing. So there are health-related issues that are coming up. Although in that, Supreme Court initially said free to everybody, then they said, okay, whoever has ability to pay should be able to pay for it. But I think it's also learning in the process. Because this is a crisis which is like never before. So from that perspective, there are various COVID-related issues that are on the priority basis being tackled by the courts, which are of the relevance. One very interesting aspect I must mention is the Delhi High Court order. There were some imports of PPEs done from China. The kind of a respondent actually procured them from China at X price, and they had a contract to sell it through Y, which is the petitioner, to government agencies, where Y, who was the petitioner, had a rate contract with the government. So actually, in order to hold the prices, and I think what happened is that PPE was this person who imported PPEs from China actually said, unless I get a margin which is 4 times my normal margin, I will not sell this to you. The court actually intervened, gave him a decent margin, which is 10% original markup that was there, and said, if you don't follow this, it will be looked at from the point of view of breach of the court's order. So, in a different form and manner, when it comes to essentials, especially the medical supplies, I think the government or the courts are also playing the role of an agency that's maintaining the retail price levels and bringing out balance all across. So I think there is a lot of hope that we have from judiciary for sure. Although people might today be confused, they might want to kind of take umbrage under COVID-19 situation, which is in any event a material event leading to material adverse effect all across. But I think the judicial trends and judicial behavior is so very promising today that that's one quarter from where we actually look forward to maintaining the balance in the overall ecosystem.
Thank you, Suhas. That was really very, very well articulated, very insightful, and you made it actually look very easy, all these concepts. Thank you so much for your time. And I'm sure some of our audience would have some questions. They can definitely address their questions by email to suhas.t@legasis.in that you see on the screen. That goes to Suhas, and also maybe addressed to Gautam at rai.net.in. And you can expect responses from here. So coming back to the webinar, Suhas, I have to really thank you again. You have done a wonderful job, and I hope all our audience equally enjoyed, and also they found it to be very educative, very useful. And we look forward to having more such webinars in the future to create more awareness around these issues as we go forward. And now that we have already past 5 o'clock, it's time to wrap up. Thank you again. Thank you, RAI, for creating this platform for us, for me and Suhas to give us a best effort, to explain all these things to all of you. So thank you so much.
Jyothi,
Thank you, Subha. On behalf of Retailers Association of India, thank you so much, Suhasa. Thank you, Jyothi ma'am, for actually bringing in the key points. And
Meenakshi.
Yep.
Hello.
Yes, sir. Yes, sir.
Yeah, Meenakshi and Jyothi, thanks very much. I think one last thing which I want to mention, and I want to pay tribute to those doctors, those health workers who are actually at the front line during this period, trying to save lives. Their lives are really, really very difficult at this point in time. I want to pay tribute to them. I want to respect them. And I must mention that it is because of them that we are able to kind of conduct these kind of digital webinars, and we are able to stay at home. From our side, we will not overwhelm the medical infrastructure, the health infrastructure, and try to reduce the burden. So we're not going to be problems, but thanks very much to all those people who are trying to save lives today.
And I think with the closing remarks, I would say that, as Mr. Kumar said, that we have to overcome this situation, this crisis situation, and look at getting back to a great normal in March 2021, and let the new normal help us to achieve that great normal, right? Perhaps with more learning, more enlightenment, newer ways of doing things, and better efficiencies and things like that. So let's all exercise restraint and still, because I can't help sharing this, Suhas, with you. Yesterday, when I was listening to on YouTube by Mr. Abhishek Singhvi, he jocularly remarked that, somebody has come up with a, and he said, what is that? So, chup chap ghar mein baito. Okay, so I think we still have to do this for some time till we really kind of get over this problem. So let this new normal lead to the great normal ahead. Thank you so much. Thanks everyone for your patience, for your cooperation, and also evincing a lot of interest by asking us questions. Hope they were all answered. Thank you once again.
Thank you.
Thank you.